say Supreme Court today sermons no akoma abansu mani babe na wono so ye was any sermons no kura minsum but mo fa krata anto so parliamentary service for mo san fa sermons nko what tribunal na ye mranim ni di asemu a
me da CP and information that say the process is different Supreme Court registry. Normally the processes are not from the Supreme Court, but from the registry of the Supreme Court that is served through the bailiffs to the appropriate agency. It is an appropriate institution. In the shows that is something that happened. Then when those processes went, say also the letter to SOSA according to Article 117 or so, no, Parliament shall not be the speaker and others cannot be sued until I send the letter to SOSA come home.
No, Sada Marane Chire. If the Article 117, ye can't one was say, Drew Yankaya Nabrofonia, Kana.
I come on,
I did. Woke over a Mamranwa 117 was say, civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to, attending at, or returning from any proceedings of Parliament. The Amranikani.
I say, Sana Constitution is 117 quite explicitly. So you say, Honorable, the Speaker of Parliament, my summary, the Speaker of Parliament is the Obai. Obabi, yeah, no.
It was here to me, sir.
Aha, not to go on summer now, Obai, and not to go 117 or my summary Parliament. Somewhere now, Parliament is some look as a Parliament in a Supreme Court. Some Supreme Court case no also to 117 or say set principles. We should set principles that will last a lifetime. Yes, because of the exigencies of the moment, as I say, because someone say, Speaker of Parliament, one is sworn in.
You caught one in a sworn in.
I mean, the short term say Chief Justice. I never saw in. These are three parallel institutions: the executive, the legislature, and the judiciary. He say, let us not engage in any unnecessary grandstanding. Say, a process is free Supreme Court bar. It is from the registry of the Supreme Court. First and foremost, the Supreme Court is a court of record. The registry is a replication of record. It is a whole problem. You are from something like a conditional appearance. Appear. You must appear. When you appear, then it's for sake of Article 117, I am unable to answer this process, but you must appear. What do you say?
Yeah, one more Yanua, one must 18. This was Yanuasa at the 18. Neither the Speaker nor member of nor the clerk to Parliament shall be compelled while attending Parliament to appear as a witness in any court or place out of Parliament. The certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance of Parliament. It's 18, 118.
Conclusive evidence of attendance on Parliament. It would the evidence in Baba. Say, one office. If you all someone got so made the category free. Now we are a member of Parliament in Timenko. You go, you attend upon the court, and then you give your reasons why you are unable to participate in the process. And you see, Ubia or your friend jurisdiction. Now it's a very, very interesting concept. Ye bamra sama Ghana ha, and my some judiciary there. And my family judiciary there.
Say yes, Shamarano, a year. Womo yen was a parliament in a Shemarano. na
Parliament.
The enforcement of the law no and omodiama executive ne am na mom say problem ba wo mum yenu ntamu a de eye na sadies wo no be address sa issue no eye the judiciary
Parliament in the beshamra no but emra no yemfanya adwuma yenchechemu yemfanhyemu kina yemfanya adwuma e judiciary emrasem equita the judiciary, that is the jurisdiction. So jurisdiction is a funny thing. Who the so beshamna, that is your jurisdiction. Who baby wana modu no. Wo shamna ni wi ani podem na ni adwuma chechi mo explain no ni jurisdiction no a judiciary. Enti asema ba who understanding of the law no is this. But the people who are inviting you know omona church the law ni never shemu kina na mo shemu kina. And almost bra. What you do is that you go before them and then you give you understanding of the law. If it is accepted, they will take it. But it becomes a very dangerous thing for you to sit in your comfort zone and order your staff, clerk, the people who work for you. So, letter command say, maybe when constitution say, intimidate member.
Record je kwanchi. Constitution no ne famba bia no de ne ho na ya no wo se ampa ya de mra no se ba se problem ba ho the interpretative and the enforcement jurisdiction of the court article 21 ne 130 no ya de ama Supreme Court no enya sa ma mra ya ne no so ama parliament kwan se anya se wo ye member of parliament ya na se wo ye speaker dia see a survey on you now they are no betimi reject it. So is it not conflicting articles? I
assume you see what I say, you know, you do constitution for transitional provisions.
Okay,
transitional provisions say obi official former official say the late Mr. Rollins, may God keep his soul. Now he works under the PNDC. Assuming I issue a writ against this person, and the person says because of the transitional provision, what you do is that you come to court and tell the court, say, because of this particular Article 34, my transitional provision is in Zimbabwe, but I have immunity under these particular clauses. So you go and then you explain your position, but you don't sit in your corner based on your own understanding of the law and do as you please. Because your family is out there, and you have an understanding of the law.
Is it not the case, Brad, we say, some of these seemingly conflicting positions of the Constitution, you know, you better view. If a constitution or no to Myanmar,
there's no conflict. There's grandstanding.
Okay.
There is no conflict at all. What we have is grandstanding. Sitting. May say I'm just and say I'm a fan. Because Mr. Bagbin is a lawyer. He knows when the court calls you, you appear. When you receive a process, you answer the process through the record. You may answer conditionally. You enter conditionally, and then you plead, say, because of Article so, I'm unable to participate in the process. There's absolutely no conflict. There's no conflict. But no, and our grandstanding, because we are the Supreme Court now, results in the Supreme Court by no, and so it is time for him to grandstand. As I'm saying, as I talk to you, I have one case in the Supreme Court. Raj on Dramani Mama, Mr. Mayor, our parliament is a defendant in that case. They have answered.
We know, baby, I do know. I think there must be a holistic look at the Constitution because who can say Constitution? I
don't agree with you. Say there must be a holistic look at the Constitution. What I will say, I'm not for shishini no manomaye. Because only say if it was on any other grandstand and Quebeco. Because our parliament, which is kind of case about LGBT, you know, okay, case, you know.
Yes.
In your parliament, you know, somehow.
And or appear ye.
Or appear almost before the same Supreme Court. I mean, the normal parliament. Asamna abandon now. For him, it is convenient to engage in grandstanding because when you are adopting principles, adopt principles that you can live with 1,000 years. No, I don't know. I send about this how I analyze it. As some about parliament is here, MPP were numbers, MPP were 150 MPs, and can any problem there of parliament. They will just kick those 3 people out of parliament, not 2 people out of parliament. And they will agree with Atu-Forson and Co. But because of the difficulty they have today, if they agree with Atu-Forson and Co, it means they go into minority, so they are changing their principle. The same thing is applying to Bagbin. Then the Supreme Court why BB, they are dragged to Supreme Court to be questioned, and not also what you apply, and no from let us not do that.
Can I tell Jay Crunchy, my senior at the job now? Was I a role model? Somebody that encouraged me. The member you should I dear sir or I am them. But we need to look at the constitution all over again. That's my position. Because here lies the case that Ebeko won a wusu am maranonia dear. Here fana catch is it 57?
34 my transition permission in Zimbabwe, but I have humility under these particular clauses. So you go and then you explain your position, but you don't sit in your corner based on your own understanding of the law and do as you please. Because your families are there, and you have a understanding of the law. Not somebody pay.
Is it not a case, some of these seemingly conflicting positions of the constitution? You better if a constitution or no to Myanmar.
There's no conflict. There's grandstanding.
Okay.
There is no conflict at all. What we have is grandstanding. May say I'm just and say I'm a because Mr. Bagbin is a lawyer. He knows when the court calls you, you appear. When you receive a process, you answer the process. Through the record, you answer conditionally. You enter conditionally, and then you plead, say, because of Article so, I'm unable to participate in the process. There's absolutely no conflict. There's no conflict. But no, and our grandstanding, because we are the Supreme Court now, results in the Supreme Court by no, and so it is time for him to grandstand. As I'm saying, as I talk to you, I have one case in the Supreme Court. Raj on Dramani Mama, Mr. Our Parliament is a defendant in that case. They have answered.
Maybe I do know. I think there must be a holistic look at the constitution because who can say constitution?
I don't agree with you. Say there must be a holistic look at the constitution. What I will say, I'm not for shishini no manomaye because only say if it was on any other grandstand and Kobeko. Because our parliament, which is kind of case about LGBT, okay, so case,
Yes.
In your parliament, somehow.
And or appear here.
Appear almost before the same Supreme Court. I'm the normal parliament. Asamna abandon now. For him, it is convenient to engage in grandstanding because when you are adopting principles, adopt principles that you can live with 1,000 years. No, I don't know. I send you about this how I analyze it. As some about parliament is here, MPP were numbers, MPP were 150 MPs, and can any problem there of parliament. They'll just kick those 3 people out of parliament, not 2 people out of parliament. And they will agree with Atu Forsen and Co. But because of the difficulty they have today, if they agree with Atu Forsen and Co, it means they go into minority, so they are changing their principle. The same thing is applying to Bagbin. Then the Supreme Court why BB they are dragged to Supreme Court to be questioned and not also what Tikapai and no from Yamenko. Let us not do that.
Can I tell Jay Crunchy, my senior at the job now? Was I my role model? Somebody that encourage in him. The member you am should I dear sir or I am them. But we need to look at the constitution all over again. That's my position. Because here lies the case now. One of who's young, but I know near there. I hear fun catch. Is it 57? So you cannot take the president to court whilst in office and 7 days. Look for that constitution, that article for me. It's a constitution, no ma. Supreme Court, no. Under article 2:1, no. Now a man, I was say, a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment or B, any act or omission of any person is inconsistent with or is in contravention of the provision of this constitution may bring an action in the Supreme Court for a declaration to that effect. 2:1 number a Supreme Court kwan say who say will be whether a year executive no, whether a year legislature, whether a year ECO when you nasi nipa no ne ye yobi ana wanya adie bi na ya hwemre bi eti na nanu no wo mo di case bi se kufa do akofa pen di akotworo se wono ne the executive power are restricted the movement of Ghanaians because of COVID. Na ya no wo say Professor Jetua ya Pia Jetua ne ade wo say dabi wouldn't say to me no e bi se Kwame Nkrumah pen so said the word executive power ne ye no ntino ya Jeffrey wonsem ana article 12:2 no dey protection of the fundamental human right no akwahye court no nsase said the be ye na de si ye rea kotoni ade na Kwame Nkrumah no dey parliament ni ye niam bi enti ye said protection of fundamental human right nya wo de bio enya kufado de anu atiki ezo person take the protection of fundamental human right no every one some under executive authority where so a different court ho by the help of parliament any ekotwa at 1019 o se de ba animo edis obi gidi say speaker any yobi no etia eye amamra no a court ne pe ane ye de say to me na ma no under 21 and 131 na ye kan 131 no a bekwe wo no yi ne ye nhwe na ye nchire mu nchire manfo no wo kan 131 no a was say subject to the jurisdiction of the High Court in the enforcement of fundamental human rights and freedoms as provided in Article 33 of the Constitution, the Supreme Court shall have exclusive original jurisdiction in A, all matters relating to the enforcement or interpretation of the Constitution, and B, all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law or under this Constitution. Edi, bakwe, when you 131 a year B, no, was it all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law or under the Constitution. In the Article 93 no, Emma Parliament kwan se obeye mra tienie emra sha no ye de Article 93 say Parliament na eso ye.